Well, if I could just ask quickly, I was a little bit confused. Are we going through the rebuttal of the property appraiser's evidence now? or
No, I'm
is
still
this your
presenting my case. I'm still presenting my case.
Yeah.
Okay.
Okay.
And you'll have a chance to rebut.
No, I didn't know if he was rebutting our evidence or
started
he was
out
presenting
as-
his case, because he kept going over our data is what I was referring to.
Yeah.
Well, my case is, I'm partly showing that they haven't met the
Okay.
standard of the preponderance of evidence, so I'm presenting my case.
Okay. I'm good with that.
Yeah, thank you.
I think we're
Okay.
confusing issues here. I think
Yeah,
what
no,
you're
I-
speaking to is a presumption of correctness, which can be
Yeah.
lost. The preponderance of evidence is a weighing of the evidence provided by the petitioner versus the evidence provided by the property appraiser, and which
No, I
one is
understand.
stronger.
I'd like
It all
to
ties
finish.
So we don't lose a
together.
I mean,
I wasn't permitted to speak during
Oh,
their
okay,
side of it.
Sorry.
May I submit my notes on this property, my annotated evidence pack? There's nothing new on them.
I was gonna say, it's the stuff he's provided.
Yeah,
Okay.
I'm just gonna.
No, what are you talking about now?
Your evidence packet with just notes, observations, no new evidence.
I would say you could testify to it.
Yeah,
We
but
don't
no.
have the opportunity to review those. and
Yes,
it's not
without
something
looking
that-
at it.
I suggested this is a matter for the magistrate's attorney.
Well, it's a matter of evidence submittal, and again, you can certainly rebut
Evidence
anything that's
submittal.
here, but
Evidence submittal goes through me, but if one side has a problem with it, then I can't allow it.
Isn't that evidence they sent you?
I'm sorry.
Isn't that evidence they sent you?
Well, yeah, and my point is, this isn't new evidence. This
It's
is
not
just commentary.
it's rebuttal.
It's a rebuttal.
And again, we certainly don't mind you going through your rebuttal, but,
Okay.
I mean, without us being able to review
I'll
all your
yield on
notes
this
and
one.
go through it.
I'll yield.
There might be something written there that you didn't speak to that may influence what he,
Fair enough.
So
okay.
let me hear about the going concern issue first,
Okay,
because that's sort of in the top of my brain and how that's separated out.
okay. With the sales that we utilized, as you'll see, we really didn't look at, I didn't say didn't look. Not a lot of weight was given to sale 1 and 3. They were in 2009. We looked at sale 2, 4, and 5, one of which is the subject property. You know, the overall hospitality industry is doing well, and it's the market that is going up that indicated to us that the property should be increased in value.
Is that comparing one year to the next, or? I mean, we always had pretty good tourists. We've always been pretty good.
Correct.
Sure.
Correct.
So, I mean,
But it
Yeah.
wasn't so good the
It
last
was,
few
yeah,
years.
2011, 10 and 11 were.
It's just,
have
yeah.
that here to
Okay.
show
And actually,
the relationship.
yeah.
You know what I'm saying?
That- yeah.
we're getting better.
and actually, that particular page is new to this particular
Okay.
survey. Yeah, so
It's
it was
fancy.
something. Yeah, it was something I found pretty interesting. It was usually
Okay.
typically in the past it's only been the 2 pages.
All right. Anything
Um,
else?
With regard to the location, he mentioned that it's back behind. It's not on the thoroughfare. The 4 hotels that are on that particular thoroughfare are very similar. As you know, if you saw, they're all, the subject is back here. There's 3 others right along here. And in fact, a developer is developing a new hotel right here, which is again back behind the thoroughfare front retail. That's not atypical. It's very typical in the market, and not something that's unusual.
And that developer
Why-
is
why
the
do you
seller
think they
of
do
the
that?
subject.
Probably the one difference is the land value.
Land
If you're looking at
value,
value
yeah.
directly on the main
Yes.
road, it's
Should be.
substantially higher than the land value would be
Should be
200
lower.
feet back.
It
Yeah.
should be, but it's double.
It's
My
double.
subject's double.
Should be.
I'll address that in a minute. On top of the fact that, you know, they're typically higher rises, you can see the signs from the road. Hotels, for the majority, are destination oriented, so it's not like, where can I stay, you know, driving down the road. So that's not atypical for the market, being back behind
Okay.
thoroughfront.
The following page are our marina lease rates. This is,
Wait a minute.
Yeah,
I'm
no,
sorry.
we already, she's introducing evidence that was not submitted to the petitioner.
I'm sorry, which,
Or are you talking about the?
we just finished that.
Okay.
No. this final value by the income approach,
Is
I
what's-
get 1,000,366.
135? Oh, right. That's what I'm saying. It doesn't, when it has to combine two income streams, there's another report that we use to do that.
Which was not submitted up, this is the first I've heard of it. Therefore,
Okay,
it's totally
the-
inadmissible.
No.
This isn't.
No, that is more accurate. This is what I
Let me
had
just
to-
explain what the difference
The
is in the
math's
final
wrong.
value.
Okay, yeah, it's a matter of having different vacancy rates, it's a matter of having different expense rates, and it's a matter of having different cap rates for two different income streams. So in this report, when it combines them, it does not combine them correctly. In this report, it does. And that's the difference.
We just testify to the difference in the final value by the income approach in terms of what was indicated there versus what was given.
Okay, can I do that?
Yeah, well, I want to know what I'm looking at. What expenses are these? Are these just for the marina?
That's just gonna be for one. That's the problem.
For one of which one?
I don't know
Oh,
which one that is, but this is the combined one for the two.
not submitted.
Absolutely. This is the first I've heard of
Okay,
it.
but,
Can I ask a question back
Sure.
on the sales comparison approach?
Sure.
What is the sales price of $176? Or is that just something? That
the 175?
176?
Oh, the sale price? There was a transaction on this property in January of 2006.
For 176.
Yeah, the building was built in 2009.
No, I'm sorry. It was there was a tenant build out in 2009. I think that's what caused the county to overinflate its. 2007 assessed at 913. 2008 673. 2009 612. Now in 2010 it went from 612 to 950, despite the market getting worse. This would account for the build out, or the what they believe to be new construction jump there. So it went from 612 once again to 950,000 in 2010. And then it dropped in 2011 to 932. And then 2012, 1.25 million.
Yeah.
I didn't see anything that justified, once again, the spike. And all the construction seemed to have been, all the construction seemed to be accounted for on the 2010 evaluation, as once again the market declined, about a 30% jump in the price between 2009 and 2010. So this seems to have already been accounted for.
Okay.
The county did acknowledge that they may have overlooked something. However, the petitioner did not get a chance to review it. Therefore, on the first page, it should reflect the value in the packet of 1 million and some change, rather than the 1.135.
Okay.
So that adjustment needs to be made.
Well, that's just an error.
I understand it's an error, but my understanding is the way the appraisal process works is they reconcile the three values.
Mm-hmm.
They reconciled, it appears, with the 1.135 number, because that was the number at the date of this publication, or at the date I submitted it.
Okay.
I didn't get a chance to review any evidence, therefore it may have been an error, but it was...
Yeah, the whole thing's mixed up.
Right.
Yeah, I get that.
The county did not just list the comps without showing any sort of adjustments. They can't just dismiss it out of hand and or argue that, hey, it was accounted for. They have to actually document the way they were adjusted or how they were compared to the subject property, which I did not see happen or do not have in my evidence pack. And we did show the one actual land sale, the multi-parcel land sale, showing a substantially less value per square footage of land. Thank you. Unloaded cap rate of 9.5%, yet they just told us that the average in Pinellas County was 8%. On page 22 of their evidence packet, it has it at about 7.5%. We are not sure how the county arrived at the 9.5% cap rate for this property. This goes towards showing that the property appraiser's office deviated from the mass appraisal standards and their own standards, overcoming their presumption of correctness, requiring the magistrate to reevaluate their value, particularly and on these sales. Sale number 21, Gulf Boulevard, it is the statistical outlier at 120, the maximum on the height range. A Gulf Boulevard sale compared to a 43rd Street, a big industrial park sale, is a invalid comp. And these are the averages they use to come up with as far as the petitioner knows, because they provide no evidence to the contrary. As far as the petitioner knows, these are the comps they use. They have one comp on Island Way, one comp on US Highway 19. These are, and most of which are statistical outliers. Comp on Main Street, comp on alternate 19, 66th Street, Park Boulevard, Dandy Boulevard, compared to, once again, a property tucked away in an industrial neighborhood with no significant traffic. If not, at the very least, they're going to use these comps. They should have addressed external obsolescence in their cost approach. But I do want to present this graph, and the main point here is that the subject property is assessed at approximately 140% above the comps once you adjust for the 15-year per day criteria. The magistrate want a copy of this packet from the Appraisal Institute?
I guess that's.
It was submitted as rebuttal evidence to the county.
I mean, if they want to object to that, they certainly have the right to do that.
I didn't see that.
I have a copy of the email once again, showing that we did in fact submit it.
Well, again, was this something that came Sunday?
In the last 2 or 3 days, yes.
We're back to the
I guess
argument that really it has not been timely. And if we thought it was really material, I mean, I wouldn't say that. I just think we're just going down a dead end street here.
And I want to remind I obviously have to remind the appraiser's office, but that they are obliged ethically to be unbiased. And so if this evidence is of significance, the ethics rules, according to USPAP, require an unbiased opinion. Therefore, there shouldn't be any games of gotcha here.
I just
We're
didn't
just
see
going
anything
by
meaningful
the
in
laws.
So, as am I, to the best of my ability. All right, I'm not hearing any.
testify verbally to it. I mean, we wouldn't obviously object to you addressing the high points of this. If there was something you want to touch on that you think
Okay,
is
well, I mean,
meaningful.
that's what I've done. The interim use, and once again, this is USPAP. Interim use of land is a common practice and is the most acceptable practice if a property is being valued for a specific period of time, i.e. the year of 2011 or January 1st, 2012. So I just would like that noted, if you would. The seller on record, and he has the rent listed here. I did not provide an income approach, but I want to note that the county did not even put in a pro forma income approach on a 5-unit or a 3 and a 2, as you would, building. It's not in their packet. So once again, talking about failing to properly consider the criteria, will overturn or overrun their presumption of correctness. This, and also failing to consider the sales, and I think we did discuss that when he learned of the sale, he did acknowledge this should have an impact. It never did adjust. So clearly, there's no issue of presumption of correctness anymore. It's just, what's this property worth? And I don't know if the appraiser's office has a revised opinion, having time to reflect, but I'll wait for the rebuttal hearing. I do know, once again, that these two particular appraisers, particularly Eric, is of outstanding character. A terrible place, and the judge said, the reason we're here having a trial is because, I saw the pictures. This is, and the code enforcement came out. This place is in quote unquote deplorable condition, and
This is the subject we're talking
yeah, the subject is in deplorable. But yet all their comps are, for the most part, in good repair. Many of them are renovated. Many of them are much newer. This is like a 1929, 1930 property. So what we did was we analyzed for just 629. We just took their list of comps on their website, and we analyzed them versus the subject just for 629. And what we came up with was that they were assessed per square at 151% over comparables, almost all of which were in much better condition. So with that in mind, The cost approach, or the sales comparison approach, was done totally improperly. They put way too much weight on it, because I'm going to show you some of the comps they've used here, and this was submitted as rebuttal evidence, and I could go over them one by one, but I mean, the picture is very clear of what's happening here. These properties are all substantially superior.
And I'm going to mark the additional document, which is the listings, as Property Appraiser Exhibit B for petition number 2012-0604. Okay, and if you would like to look at this, all right.
Wonderful. Well, when Mr. Brown started, you asked him if he had adequately addressed all 8 criterion. When I originally contacted Mr. Brown, as it's reflected here in this email, and I do see how I could have missed it because it was attached to the attachment I sent when you replied back, and so I'm sure I got it. However, when he claimed that he had carefully considered the 8 criterion, after the valuation was done, when I was contracted by the taxpayer, I provided him with the actual 2011 income tax return showing a loss of $21,444. One of the criteria is the income of said property. Mr. Brown did not see this as grounds for changing the property's value. Rather, he stuck with his assessment that the property was performing at a remarkable cap rate. And once again, this all goes towards overcoming their presumption of correctness by showing that they didn't carefully consider that, as well as my next piece of evidence here, which is the only relevant MLS data for the property, which is its 2011 MLS and LoopNet listing. What Mr. Brown has submitted is a listing which all I have on date on this is 10/24/12 in the bottom of the email for this year, which is nearly 11 months past their lien date. In either case, it deviates from their standard practices. That is, I submitted a MLS that was on the market at year end, right, before and on the lien date. And once again, this is a...
And do you have a copy of that? Was that
Yes.
submitted to them?
Oh yeah, that was certainly submitted to them, and here's
What?
a copy for you.
Right, why don't we make sure that gets into the record?
Please, let me just make sure. Okay, so here, 1.5 million. And here's the MLS.
Okay, let me go ahead. And are these two
Which
connected?
Which one is that?
One's LoopNet, one's MLS. And
Is this?
Are these all the 1.5 listings?
yeah, you just handed me the same, right, the same
It's
copy.
the same one I gave you?
Yes.
Okay.
Why don't we put these two together?
Sure. And so to speculate that the only reason to admit this that I could see is to speculate that the owner believes, and this is what Mr. Brown had told me over the phone, that this shows the owner's belief that his property has risen this year past the lien date.
That's not correct.
Okay, well, that's my recollection. But in either case, I don't know why they would submit this. That is, I see no why this would be considered evidence. Shows bias, and it once again helps to overcome their presumption of correctness. Okay, but this goes towards, once again, not factoring in all the relevant data. An appraisal is only as good as the data used, and this is better data than anything I saw in their packet. This and the income statement they didn't even consider.
Which is the listing, you're saying?
The listing and
As of the date of value?
yeah, as of the lien date,
Okay.
January 1st.
All right.
And the income statement, one of the 8 criteria flat out is quote unquote the income of said property. And I submitted it to them and they did not change the value of it. They still maintained, well, now I want to go through their packet.
I know you submitted it and the property appraiser's office received it, correct?
Well, I have to see what he's presenting. This is what we've received in
This.
attachments. Oh, that we did receive, that's
Yes.
correct.
And so they've had an opportunity to consider it and look at it for today's hearing and they haven't changed their value on it.
That's correct.
Page 11, vacant beach land sales for Gulf of Mexico frontage, intercoastal frontage, and non-water frontage. I'm going to pull out a note, a USPAP, an Appraisal Institute note
Mr.
from...
DiMarco, I'm sorry to interrupt. We can shorten this part of your testimony. If I could just ask Mr. Brown one question. With the beachfront vacant land sales used in the valuation?
No,
of this
sir.
property?
Sir,
They
don't apply.
I appreciate that. I'll just, if I may, and if they want to argue that, you know, that it's highest and best uses, like they did a fully retail analysis, like it was a giant, you know, Marshalls or something, then they need to do. I mean, they didn't even touch on that. So their appraisal, I mean, I've overcome the presumption of correctness on multiple levels. Once again, their sales approach, they didn't consider the MLS. They compared it to invalid comps.
Mr. DiMarco, did you actually complete a cost approach?
No, sir. The statutes don't require me to do so.
Did you actually complete a sales comparison approach?
No, sir. The statutes don't require I do so. They require I overcome your presumption of correctness and then put forward a logical or a empirically based way of demonstrating what the property is actually worth, if I choose to do so.
Did you physically inspect all the comparable improved sales that you used in your evaluation?
No, sir. The property appraiser's office this year.
I'm asking you questions. You can
Oh, okay.
ask this question.
No.
You can write that question down and ask it.
No.
Is it your opinion if a property is bought with some improvements on it, but shortly after the sale date that the improvements are tore down, that sale is representative of an improved sale?
Not necessarily, no. That is, I don't know what the owner's intention is.
Did you try to qualify the sales with either representative of the
The best I had with the data available, as your office did, sir.
I'm sorry, that.
I didn't ask you a question. I answered your
You didn't
question.
Let me finish
Oh.
the question. My question was, did you verify any of these sales with a representative or the owner of either the buyer or the seller?
I can tell you that I work in commercial real estate and that I've had a dealing with a number of Pinellas County properties. I did not have that. I just simply haven't noted, oh, I've been to this one, or I've seen this one, or I've talked to this guy about this one. I'm just being very honest with you. I don't recall which
So
ones
you
I
may
would or
have
would have.
verified
I'm
some and the
familiar with
other,
the market.
but you don't
Right,
have
right.
notes or anything?
I didn't take notes. I didn't think this. I've never heard this before.
Vacancy and
And just for the record, how did you apply the adjustment on the cost approach? So I don't believe you really addressed that. It was 345, 124, and you made an
85.
adjustment.
Oh, the adjustment is on the cover page at 293, 355,
Right, that's the adjusted
That's the
amount, but
adjusted
how
amount.
did you get there?
85. Well, let me do the math to make sure.
This calculation is just stated, full amount times 85%.
Okay, thank you. And that applied to the other petition as well? Okay.
Yes.
It just wasn't stated on the record.
Yeah, sorry, I just figured I better calculate and make sure since
Sure.
I'm stating a number.
And
Okay.
they have the effective age is only 31 years. But this property, I think we said was 66, right?
Yes.
Okay, so, but they have the effective age as if it were in much better condition for its age.
Excuse me. He said they had the property at 66. What does that mean? You mean built in 1966?
Built in 66.
Thank you.
Yes.
Right, so the effective age would lead one to the conclusion that it was in better than average shape for its
So effective age of 31 years, but you're saying the actual...
effective age is about 40. You know, it's almost, I mean, all you got is the shell there as far as any real value. Okay, so they have external obsolescence at 0% in their cost approach. However, this property has a substantial external obsolescence issue, which I've documented with photographs. You cannot see it until you're past it, or until it's right on you. The view is blocked by some huge hedges, and you cannot see the building until you've already passed it. So even though it's got a pretty good location on there on Causeway Boulevard, it has this terrible issue of external obsolescence, other than the fact that the building's an eyesore. So that's page 2, and that's...
I'm sorry, other than what?
The building's kind of an eyesore to begin with, but the fact that you can't even see it till you're right up on it and you look to the right, and as you're going, you know, and the appraiser's gotten some assistance throughout the hearing from gentlemen that aren't on the record or haven't been sworn in.
They're not testifying.
Okay, well, I just wanted to note it, you know.
So noted. They are observing.
But they are
And they-
interacting and passing notes and so forth.
I understand,
Um,
but they haven't testified.
Right. So I have here a list of expired sales. I did not graph them for this property. But once again, you'll see that much substantially nicer properties are selling for substantially less than what this is assessed at in 2011 from LoopNet.
And was this information?
Yes, sir.
Okay. I'm going to go ahead and mark this as petitioner Exhibit 3, which is a listing of LoopNet listings, or a group of LoopNet listings.
Expired LoopNet listings.
Okay.
I'm sorry, Mr. Brown, the improvements since 2007?
The property record card, you have the,
Oh, yeah, it was the page right before.
these are permits right there.
Right. Because I have them on the MLS here.
They show values and dates.
Yeah, we can't tell if these are to fix a sinkhole or what they are. I don't have, in the MLS, I don't have any, oh, no, I have the same ones there. Okay, so we don't know.
Okay.
All right, and as long as they brought it up, I was gonna let us all out earlier, but as long as they brought it up, I do want to quickly point to a Department of Revenue publication on their website. And it's Florida statute. I don't know if a copy, in general, this was on my general reference guide I sent to the appraisers, but in either case, a Florida statute, for each sales transaction disqualified by a property appraiser, the property appraiser shall document the reason for disqualification of the sale in a manner prescribed by the department. It goes on to say, for example, ... manner prescribed by the department. The appraiser has attempted to disqualify many of my sales on my cases today. However, they have not complied with Florida Statute 195.0995. So they have not, and then it goes on to say, before the department will consider...
195.0955?
0995.
Okay.
Florida statute. And I'm quoting specifically, these are excerpts from a DOR publication titled Sales Qualification on their website, so it's their own stuff. Before the department will consider such a sale disqualification decision, the county must provide the department credible, verifiable, and documented evidence that justifies the disqualification of the sale. I haven't received any of that for a single disqualification. Such evidence must reflect the research and analysis performed by the county that justifies the disqualification decision. That was in a memorandum April 11, 2006. I contend with that interpretation of the statute. That is, why should they be exempt from it for the taxpayer and yourself, the magistrate? So they haven't documented any disqualifications.
Well, let me just say, in my few examples, I explain one of your sales as being unqualified. I did give you an example where...
Why don't we back up a little bit? And there are some sales on the sheet submitted by the petition. Why don't you go through each one?
Okay, well, I've got...
On the ones that are unqualified.
And the only other thing I said is, he absolutely correctly cited the statute, so to the extent that Mr. Special wants to take it under consideration.
We're interpreting, we're just the difference in interpretation. I see no reason why they should be exempt to just make any claims.
I think I understand the issue. She's saying that they must meet that qualification for the purpose of qualifying or unqualifying a sale, but not necessarily for the purpose of the hearing.
Let me ask, if they're carefully reviewing these and they have this documented already for their own purposes, why not bring it in and give it to you and me?
Well, that's
Or you
fine,
and I.
and let's see what we come up here with on the ones that
So
were submitted.
I'm going to go on the record objecting to all of their claims that any of my sales were disqualified, unless I see it in writing. And,
Well,
some of them-
they gave some reasons that they were bank sales and other reasons, but
that
I
in
was
itself-
having them generalize, so we can get specific.
And they also do show up online. The sales for each parcel will show up as a qualified or unqualified, UI or...
Right, but he's saying what qualified or unqualified that sale.
Well, we're at an
that evidence has not
evidence-based
been
hearing,
presented.
right.
Right, and when I was speaking earlier about a parcel that was financed by the seller, they retained an interest in a property, that's a reason for unqualified.
Well, we got a list right here of this
Okay, well,
list.
he's got that list, but I've got to correlate it to...
Well,
Yes.
And
That's
whatever
what
you
I'm-
need to do.
That's what I'm doing right now.
Okay.
And I will point out that just the fact, once again, according to the DOR and their sales qualification workshop, in which I was just citing from, you know, any single factor such as just the fact that it's bank owned is not automatic grounds for disqualification. In fact, the DOR lays out very specific grounds for disqualifying a property, not just vague. Oh, well, this was a bank statement, and oh, the owner held a little bit of paper on this one, and so these aren't legitimate rebuttals to my evidence.
Also, we also physically inspect every sale property in the county.
That is, you go inside and you look around and
I
you
said
document.
I said we physically inspect. I didn't say we go inside people's.
All right, the way I'll
residential-
physically inspect 100 properties on the 15-minute drive home. The way I'd physically inspect 100 properties on the drive home or during my...
That's not correct.
Okay.
We get out of the car, we knock on the door on residential homes. We go inside the commercial properties if they're readily available during business hours and inspect both the interior and the exterior of the building. We check the measurements to make sure they're correct. And that's done for every property. And if a property subsequently torn down, we take that into consideration as a land sale, not as an improved sale.
It hasn't always been my experience, but we have our differences of opinion. Ms. LeBlanc, I'm sorry, I was packed up 10 minutes ago, but they need me to address a few more points here.
One comment. The petitioner can develop his own methodology of sales comparison using unqualified sales or non-similar type properties. Our comparables are all strip centers in Pinellas County, none of his work. So we list them all, good or bad, wherever they fall in the range. We don't sort them. We don't get rid of the ones we don't like. They're all there for what they are.
Then how do you determine the value? You don't do anything with them.
We analyze the value. We analyze transactions.
And where is that?
We make qualitative adjustments, Mr. Special Magistrate.
Okay, so then now I have to read one thing. The concept of appraisal judgment, and what I'm trying to get to, and I know we have parties with sick children, et cetera here, but the concept of appraisal judgment does mandate that.
And just for the record, we're going to give you as much time as you need.
I know, I understand. I didn't mean for that to be taken seriously. The quality of appraisal I'm in the DOR, I believe it's the DOR manual. Yeah, apparently the DOR 3.2.6, concept of appraisal judgment. Like they said, an appraisal is more of an art than a science. Even quantitative appraisal analysis requires the use of appraisal judgment. The importance of data completeness and accuracy. All data used in the mass appraisal process must be as complete, accurate, and consistent as possible. The following four excerpts emphasize both the relative and absolute importance of data quality in the mass appraisal. The quality of the available data will more than anything, it goes on to say, anything determine valuation accuracy. And they're required to determine whether property, that goes on to another. Okay, so with the concept of once again saying it's only as good as data. So the appraiser's office is saying, well, yeah, sure, we submit these lists, but we very carefully compare it to other properties that are more relevant, and we do basically the equivalent of a fee appraisal on each property. And if they do that, this is where you put it. You put it in your evidence packet. So they've essentially just. I'm so kind of dumbfounded or struck by their argument here. Oh yeah. Well, of course these are just a list of a bunch of properties, some of which are kind of not all relevant, but. At the end of the day, we do have a method for where we go in behind the curtains and compare to very similar and make all these adjustments and all that good stuff. We just don't document it. It's done somewhere in the magical mystery machines processing. So that's my big concern. That I had to respond to their last remark and kind of what they've been alluding to throughout these hearings.